last compliance webinar for this 2023. So for today, we're going to do kind of a roundup of some of the key compliance issues that have come up over the past year and give you a little bit of an advanced view of what might be coming down the pipe in 2024. My name is Kim Stanger. I'm the head of the firm's Health Law Group and appreciate your participation in these. Disclaimer, we're going to be going just very fast. Don't have time to go into a lot of these items in depth. So my goal really isn't so much to explain these issues as to alert you to the issues and direct you to resources. I'm not going to do any kind of a detailed analysis. I may not be able to cover all the issues relevant to your organization. For example, for those of you who might be SNFs, there's a lot of developments for SNF compliance, but I'm going to be focusing primarily on hospitals, physician groups, other types of providers, the issues that kind of across the whole provider spectrum. And of course, remember state laws. I'll be talking about federal laws here, but you got to be aware of any changes that have occurred in your state laws. With that said, let's get into it. First thing is the new OIG, General Compliance Guidance that they've issued. As you know, way back when, 15 years ago or so, 15, 20 years ago, the OIG came up with its Supplemental Compliance Program guidances to help you in establishing effective compliance programs. These program guides are not mandatory. They're voluntary, at least for entities other than SNFs. So it's not binding, but the benefit is if you comply with these compliance program guidance, you have an effective compliance plan in place, then under the federal sentencing guidelines, the government will presumably go easier on you. Under the old process, they would give industry-specific guidance. Under their new scheme, they came out with a general compliance program guidance that applies across the healthcare industry. And then in 2024, they're going to be coming out with industry segment-specific compliance programs. Those aren't going to be published in the Federal Register anymore. If you want to receive those, then you can sign up for the government's listserv, the OIG listserv, so that you can get notice of those. Otherwise, they'll be posted on the government's website. This new General Compliance Program guidance is pretty user-friendly. It really is a helpful resource. It has a good summary of the key compliance issues that come up. They've added some. Obviously, they include the regular favorites, right? Like Anti-Kickback Statute, START, False Claims Act, and the like. But they've added the information blocking rule, compliance issues with grants and contracts, and HIPAA privacy and security issues. In addition to having a brief, good background concerning discussion of those laws and their requirements, they also go through the 7 elements of an effective compliance program. These really haven't changed too much, except that they have added risk assessment there. So they're not only expecting you to look retroactively to audit compliance, but also to do appropriate risk assessments to make sure that you comply prospectively. They've also got guidance for adapting your compliance programs for small and large entities. They've added new sections that talk about other compliance considerations in today's healthcare industry. It's changed a lot in the last 20 years, including a lot of investment in tech or private equity, things like that. So they've added sections in this compliance guidance that encourages you to consider some of these other issues when you're establishing your compliance program or evaluating compliance. It also contains a good resource or bibliography of other OIG resources that are out there to help you educate your staff and also evaluate your own compliance. So if you haven't looked at that yet, then I would encourage you to make sure that you get that General Compliance Program guidance and take a look at it. All right, next one, the end of the public health emergency. No surprise here. I even hate to bring up COVID-19, but the public health emergency ended, as presumably you all know, unless you were living under a rock. It ended effective May 11th, 2023. But a lot of those flexibilities that were in place, most of those have ended, not all of them. But you need to make sure that you have gone back to the prior standards to the extent that those prior standards apply. So for example, some of the provisions that would allow broader reimbursement, Stark Law waivers, increased telehealth flexibility, staff licensure, all those types of things, a lot of those have gone away. So it might be helpful for you to call up the CMS's summary of the waivers that existed during COVID, walk through those, make sure that you, those that have not continued on, that you have gone back to the way that things should have been and the way things are required to be right now, to make sure that you're not unwittingly not in compliance because you're continuing to comply with COVID flexibilities that no longer exist. When it comes to the COVID-19 waivers, just beware of the fraud and abuse issues. That's been a real target for the Department of Justice, is going after fraud and abuse related to the COVID-19 flexibilities. So make sure that you take a look at that, and your submissions to the government are consistent with the requirements. All right, that's it for fraud and abuse until a bit later, but we're going to turn from the COVID-19 pandemic to cybersecurity pandemic. It's kind of the other pandemic out there that's really affecting healthcare. No surprise, hopefully you realize this, that it's a huge issue. In fact, if I were going to identify the top compliance threat I think that you guys face, is probably going to be cybersecurity, because of the potential consequences that can rain down upon your head and the heads of your patients. There's been a huge increase in that. That's gone on for several years. Between 2018 to 2022, there's been a 278% increase in ransomware. That seems to be the real problem out there for healthcare entities. It's not only a compliance issue. In fact, it's not even primarily a compliance issue. Cybersecurity protections are essential just to save the life of your patients. Imagine what would happen to your ability to provide care if all of your systems were locked down. How are you going to provide effective care? So it's critical to your ability to care for your patients, as well as maintain the life of your particular organization, compliance issues aside. Because of its importance, the government has really been focusing on cybersecurity, including in the healthcare context. Just on December 6th, as a Christmas present to all of you, HHS published its strategy for strengthened cybersecurity for the healthcare industry. This gives its game plan for what it plans to do in order to help beef up cybersecurity in healthcare. Among other things, they identified 4 priorities. They're going to establish voluntary cybersecurity performance goals that hopefully you will adopt. The government will provide resources to incentivize and implement cybersecurity practices for those of you who may not have enough assets to implement it on your own. Those are the kind of carrots. If you're worried about the stick, or you're wondering about the stick, they're also going to expand their enforcement and accountability efforts. Among other things, they have indicated that they are going to include additional cybersecurity requirements for hospitals through Medicare and Medicaid, presumably the conditions of participation. They're going to update the HIPAA security rule to include new cybersecurity rule requirements. We can anticipate that in 2024. They're going to move for increased civil penalties for non-compliance, and they're going to increase resources. They're going to Congress to see if they can get more OCR personnel to increase the resources so that they can step up their audits and their investigations of potential non-compliance. So if you haven't done it before, you really need to take cybersecurity seriously. Fortunately, HHS has provided a lot of resources that we'll talk about in just a minute. That's another thing that they've got on their agenda. They want to make sure that HHS provides a one-stop shop that you can go to for cybersecurity resources. Going back to those penalties, certainly they can impose penalties under HIPAA. As you know, HIPAA penalties can range anywhere from $127 per violation up to approximately $2 million per violation. If you do not act with willful neglect, the good news is that you can avoid a penalty so long as you correct the situation within 30 days. If, on the other hand, you act with willful neglect, it's a mandatory fine of about $13,000 up to potentially $2 million per violation. Those violations can add up quickly when you start talking about the improperly disclosed patient information. Each different patient whose information is disclosed, that's a separate violation. If you didn't have your safeguards in place, then each day you didn't have those safeguards in place, that can also be a separate violation, resulting in major penalties. If you want to avoid those penalties, well, under HIPAA, it's not all that hard. You just need to avoid willful neglect and then respond appropriately if there is a problem. To avoid willful neglect, you generally need to make sure that you're complying with the PHI, the privacy rules. That means you don't access, use, or disclose the protected health information without the patient's authorization or an applicable HIPAA exception. You've got to implement your safeguards. You've got to train your workforce members and document. You've got to execute business associate agreements, honor the patient rights under PHI. If there is a breach, you need to take appropriate action to mitigate it, and you need to sanction your employees. Now, the key here is if you have done these steps, right, as an organization, you just have a rogue employee who messes up, that's not willful neglect on you. The commentary from the enforcement rule says that that is not willful neglect on your behalf. So that means you can avoid penalties under HIPAA, at least, if you can document that you put everything in place and you just had a rogue employee. So you want to make sure that you do that. Under the security rule, it requires you that you perform and document a periodic risk assessment. You've got to implement the required administrative, technical, and physical safeguards, and you've got to execute your business associate agreements. If you do that, then you can generally avoid HIPAA penalties. If you don't, however, the penalties can rain down upon your head, as a couple of recent cybersecurity HIPAA cases show. Just on October 31st, appropriately for Halloween, the government entered its first settlement based on ransomware. The particular organization had to pay $80,000 as the result of a ransomware attack. I think you should view this as a warning shot. In the past, I think that the government has gotten easier on ransomware attacks because, they can come in even if you do everything right, pretty much right. But now I think the government is upping the game and expecting you to do more. In this settlement, their published settlement, the OCR director, Melanie Fontes, said that our settlement highlights how ransomware attacks are increasingly common in targeting the healthcare system. This leaves hospitals and their patients vulnerable to data and security breaches. In this ever-evolving space, it is critical that our healthcare system takes steps to identify and address cybersecurity vulnerabilities, along with proactively and regularly reviewing risks, records, and update policies. These practices should happen regularly across an enterprise to prevent future attacks, i.e., you're on notice now that you need to make sure that you take appropriate steps. But it's been that way for a while. In 2023, Banner Health got hit up with $1.25 million arising out of a hacking incident. In that situation, some of the alleged misconduct that gave rise to that settlement was potential violations included a lack of an analysis to determine your risks and vulnerabilities, failed to do that risk assessment, that periodic risk assessment that HIPAA requires, insufficient monitoring of its health information systems activity to protect against cyber attack, failure to implement an authentication process to safeguard its ePHI, and failure to have security measures in place to protect the ePHI from unauthorized access consistent with the security rule. Well, the HIPAA penalties are certainly something you need to be concerned about, but in the grand scheme of things, it's relatively minuscule to just the practical penalties and consequences that will rain down upon your head. Based on the most recent survey that I've seen, the average cost of a healthcare data breach in 2023 is up to approximately $11 million based on a recent research. A ransomware cost, the average for that is about $5.1 million. So I'm less concerned about the HIPAA penalties, the regulatory penalties, than just the cost that you guys are going to have if you get hit with one of these things. So you need to make sure that you comply with the rules, but also not just for compliance sake, but to make sure that you are protecting yourself. As I mentioned, the OCR and HHS have published a whole bunch of resources to help healthcare entities comply. This particular website, the OCR, provides different guidance for you, including newsletters, a cyber incident response checklist. You can sign up for the OCR listserv to get additional guidance and resources. The OCR has been actively publishing webinars over the last year or so, talking about different aspects of the security rule, including in October, they did one on how the HIPAA security rule can help defend against cybersecurity attacks. They also updated their sample template risk assessment tool that you can go onto the government's website and access that. There's an OCR webinar specifically talking about how you can use that. So bottom line is you need to take that seriously. HHS also, in addition to OCR, has a bunch of resources out there. They actually have a task force that provides resources to help mitigate against the threat of cybersecurity. You can go to this website and it has a whole wealth of resources on there. They've also updated their cybersecurity practices guide, which is really a helpful, user-friendly guide to help you realize, identify, and respond to potential threats, including things like social engineering, i.e. phishing, ransomware attacks, loss or theft of equipment or data, or the like. If you haven't reviewed this, then you really need to do so and make sure that you're taking appropriate steps as outlined in this guidance in order to protect your particular organization. The HC3 also has a website that's kind of for your technical folks that gives you all the technical info on out there on the threats that are out there. They will give you sector alerts and the like. Those are some resources to help you in your compliance. Now, some of you may not be the nerds, the IT nerds. You may think, well, it doesn't really apply to me. Here's another one that might apply to you, though. Just in the October 2023 OCR cybersecurity newsletter, they published guidance on implementing sanction policies. Remember, one of the requirements under HIPAA is that you've got to impose appropriate sanctions against somebody who violates it. This whole newsletter was dedicated to how implementing appropriate sanctions can help ensure cybersecurity protection. If you haven't looked at that, you may want to take a look at that and get some guidance on appropriate sanction policies. It's not just HHS and the OCR who are getting involved, but the FTC is also ramping up its efforts on cybersecurity issues. They're using the Federal Trade Commission Act to go after, Section 5 to go after entities for data security breaches. The theory there is it prohibits unfair and deceptive trade practices, and they're claiming that if you are out there representing that you've got secure practices and you don't, then that is a basis for coming after you. You look at some of the recent cases that have come down, it's you got to be concerned not only about HHS, but the FTC coming after you for cybersecurity issues. If you're a publicly traded entity, the SEC just published new rules for publicly traded entities. So make sure that you're complying with cybersecurity stuff. In other HIPAA and data privacy rules or news, you can look at some of the HIPAA recent settlements, and it kind of is a good summary of some of the things you need to be looking at. Not only ransomware, cybersecurity issues, but some of the other hot topics like failing to provide patients with access to their records. The OCR's right of access initiative is still going on. I think they're up to like 45 settlements against entities because they did not provide the patients their personal representatives timely access as required by the rules. If you haven't looked at it recently, you really need to go back and look at the OCR guidance that they published on the right of access. You can access it there at that website up there. It's really a helpful primer and addresses a lot of the questions I commonly get on patient access, how much you can charge for records, when do you have to send the records to a third party, all of those types of things. It's important for you to do that in order to comply with your HIPAA requirements. Another issue that's come up in HIPAA, and actually not only with HIPAA, but the FTC has also warned against data tracking technology. This is that newsletter you probably saw that came out that talks about if you're using some kind of a vendor that's tracking people who visit your website and that may actually violate HIPAA as well as FTC rules. I don't like the analysis. I think the analysis is flawed. Nevertheless, there you go. The FTC and the OCR has warned you against those data tracking technologies. You may want to take a look at that guidance and make sure that your organization is complying with those rules. The OCR has been concerned about HIPAA in the context of telehealth. Back last year, in 2022, OCR published guidance concerning HIPAA concerns in audio-only telehealth. In August of this year, during COVID, the government had relaxed the HIPAA security standards to allow for telehealth. Those relaxed standards that would have allowed you to use, Facebook or Facebook Messenger or I don't know all those things, Zoom, those types of things, to do your telehealth. Those relaxed standards have gone away. Now you're expected to make sure that your telehealth platform is complying with the security standards. In October, of 2023, the OCR published guidance for providers and patients concerning privacy and security risks in telehealth. So if you are engaging in telehealth, it might behoove you to download a copy of that, take a look at it, and make sure that your telehealth platforms and your telehealth practices are consistent with HIPAA requirements. Just a heads up of what's coming down the pipe. There are still those proposed privacy rule changes. Those have been in place since 2021, but they still have not been finalized. I'm assuming that they will come down the road here pretty soon, but we still have not seen those. Just make sure that you're aware of those or watch for those. In addition, as I mentioned earlier, the government is planning to update the security rule requirements to address cybersecurity issues. SAMHSA has also proposed changes to its Part 2 rules to align more closely with HIPAA. We've got the statute that came out a couple of years ago that requires that, but SAMHSA has not caught up with that. They've not implemented the rules yet. They've issued the proposed rules. Watch for that because that will create significant changes for those of you who are covered by Part 2, your federally assisted substance use disorder programs. Most of those changes, I think, are going to be really helpful to you, but make sure you're aware of that. The FTC is also beefed up enforcement of its health information breach notification rule. Now, this is the rule that applies to vendors of personal health information. It doesn't apply to covered entities or business associates, so it probably doesn't apply to most of you, but if you are a vendor of personal health record, then you've got to make sure you comply with the breach notification rules under the FTC rules. The FTC has proposed new rules that will actually strengthen enforcement under the health information breach notification rule. They're actively enforcing that. There were big headlines when GoodRx had to pay $1.5 million in one of the first enforcement actions to enforce the health information breach notification rule. The states are also enacting their own data privacy laws, so monitor your own states as well as the federal government when it comes to that stuff. All right, let's switch from keeping your information private to sharing your information. That is the information blocking rule. Under the information blocking rule, the whole concept here was that, hey, it promotes healthcare if we can share certain kinds of information consistent with applicable law. So the information rule applies to actors, including all healthcare providers, but also developers or offers of certified health IT and health information network or health information exchanges. For those actors, which is presumably all of you, it prohibits information blocking, which is defined as the practice that is likely to interfere with the access, exchange, or use of electronic health information if you're a provider, you know the practice is unreasonable and likely to interfere. If you are a developer or a health information network or health information exchange, if you know or should know the practice is likely to interfere, then you can get hit up with penalties under the information blocking rule. Now, a lot of you probably haven't been too worried about the information blocking rule, justifiably so, because there really were no penalties until this year. In September, the government finalized the final rule that says for software or health information technology developers and networks and exchanges, you can get hit up with up to $1 million penalty for violations. For you healthcare providers, the rule just said that the government was supposed to establish appropriate disincentives. We didn't know what that would be, but we now have a proposed rule. As of November 1st of this year, the government issued proposed rules. Under this proposed rule, the disincentives would be that, hey, if you're a hospital and you have violations of the information blocking rule, you could lose your status as a meaningful user of EHR and therefore lose your federal subsidies. For providers, you could lose your status as a meaningful user under the MIPS and therefore could lose, again, your federal subsidies under the MIPS program. If you're an accountable care organization, you could lose your eligibility to participate. The bottom line is, by violating the information blocking rule, you could lose federal money. So if you haven't worried about it before, it is now time to worry about the information blocking rule. For more information about those disincentives, you can go to this particular website. It'll explain it more fully. Just remember, though, those were proposed rules. We'll have to see how the final rules come out. Now, what is information blocking? It could be refusing to timely respond to requests for information, charging excessive fees to access information, imposing unreasonable administrative hurdles, imposing unreasonable contract terms in your EHR agreements or BAAs that prohibit the access or denying access to other entities, implementing health IT in a non-standard way that increases the burden on others. Basically, it's anything that would unreasonably restrict the access. Well, what is not information blocking? Well, if the action that you're taking is required by law, so for example, HIPAA prohibits you from disclosing the information, then that's not information blocking. Or if, like in HIPAA would allow you to do it if certain conditions are satisfied, but if those conditions aren't satisfied, then that's not a violation if you do not disclose the information. If the action is reasonable under the circumstances, it's not information blocking, because information blocking is defined as the unreasonable blocking of access. Or if the action fits within certain regulatory exceptions. There's 8 different exceptions. They're relatively complicated, and I think personally they're hard to satisfy, but nevertheless, there they are. The OIG has published its priorities in determining which cases it's going to go after. Interestingly enough, or significantly, the OIG only goes after the enforcement against developers and networks and exchanges. For healthcare providers, that would be handled through CMS, through those other processes. For more information about the information blocking rule, what it is, what you're expected to do, you can go to this website and get that information. All right, let's go back to fraud and abuse. You knew I was going to get to fraud and abuse because I like talking about the fraud and abuse stuff, including the anti-kickback statute, Stark, false claims, and the like. Bottom line here, no major changes in the anti-kickback statute. You just better comply with it. If you don't, you can be hit up with those civil and criminal penalties, and it can trigger False Claims Act liability. There was a new safe harbor that was issued. It actually issued last December. It now allows hospitals, ASCs, and SNFs, and certain other entities. You can offer a bona fide mental health or behavioral health improvement or maintenance program to physicians. So if you want to do that, you can offer that, set that up under the requirements under the safe harbor, make that available to the physicians in your area without violating the anti-kickback statute. Remember that there are also those other safe harbors that were enacted back in 2021 that it's easy to sometimes forget, including a bunch of new safe harbors for value-based enterprises, care coordination, and that type of stuff. The OIG has also published a bunch of new frequently asked questions on the anti-kickback statute that answers a lot of questions that commonly arise. So if you haven't looked at that, I encourage you to hop on there and take a look at that and get some additional guidance concerning the anti-kickback statute. All right, there's also the Eliminating Kickback and Recovery Act. No real new developments this past year. I just wanted to bring it up to make sure you guys remember it because it's easy to forget about it. But if you are covered by ECRA, that is, you are a provider of laboratory recovery homes or clinical treatment facilities, you got to be concerned about ECRA because it is worse than the anti-kickback statute. Note that it applies to entities providing labs. That's not just SUD entities, substance use disorder treatment facilities. That's any entity providing labs. If you are providing labs, you got to make sure that you're complying with ECRA. I just wanted to remind you of that. And those safe harbors that might apply in the anti-kickback statute under Stark, those don't apply in, or may not, usually don't apply under ECRA. So beware of ECRA. All right, that brings us to Stark. Got to comply with Stark if you're a provider of designated health services or a physician who's making referrals for designated health services. Make sure that you're complying. There is, if you don't comply, then you do have an affirmative obligation to report and repay back to the federal government. The government had a huge backlog in Stark's self-disclosures. In 2022, the government has been really taking strides to resolve that backlog, and they've encouraged in some situations entities to actually withdraw from the SRDP based on guidance that the CMS has provided concerning Stark that makes it easier to comply with Stark. They've allowed people to withdraw. The bottom line there is that if you do have a Stark violation, then I'd encourage you to look at some of the recent guidance that comes out because it can help you through the Stark self-disclosure. It may actually allow you to avoid self-disclosure in certain circumstances. In my experience, CMS is a lot easier to deal with than the OIG when it comes to these issues. As far as other Stark developments, there is also a safe harbor, just like there is for physician wellness programs under the anti-kickback statute. There's also one under Stark. Also remember that back in 2021, they did an overhaul of Stark, a lot of new changes. Don't forget about those. Those are still out there. A lot of people don't seem to realize or know that those are there. All right, let's talk about the False Claims Act just briefly. It's still out there, including for situations where you violated Stark or the anti-kickback statute. You're probably going to have an obligation to report and repay under the False Claims Act. This recent Covenant case that came out in 2023 is a good textbook of why you need to comply with Stark and the anti-kickback statute, how it can turn into a False Claims Act violation. In this situation, allegedly Covenant healthcare system. Again, this is alleged. They settled it out, so there was no final decision, but according to the settlement, at least, they were alleged to have medical directorships and where the directors were paid more than fair market value. They were providing free PAs, billing and administrative support to referring physicians, remuneration without fair market value or documentation to support why they were doing it. They were paying overhead costs of referring physicians. They were billing Medicare and Medicaid for services provided without supervisory physicians on site. And the bottom line is they failed to maintain the documentation that they needed in order to justify the compensation they were paying. $69 million later, they resolved those claims with the government. You just need to make sure that you're aware of and periodically review your transactions with referring physicians for Stark, or referring physicians and other providers, any other referral sources when it comes to the anti-kickback statute. The government, of course, is continuing to actively prosecute False Claims Act situations. They announced that for 2022, they recovered $2 billion through the False Claims Act. That's the second highest in history. As far as other False Claims Act developments, there was a noteworthy federal case, United States Supreme Court case, in which they confirmed that violations of the False Claims Act depend on the plaintiff's knowledge and subjective belief, not just an objective argument. So just because you've got an objectively good faith argument based on the interpretation of an ambiguous law, that's not necessarily defense under the False Claims Act. They'll look at your intent, whether or not you knew what you were doing was not justified or reckless. You can look at some of the recent OIG self-disclosures. Again, it's a good summary of the things you need to be aware of, including, among other things, submitting claims for persons who are not licensed, misidentifying the providers, misstating services that are being claimed, and the like. Remember, when it comes to Stark and the anti-kickback statute or violations of civil monetary penalties law, if you want to, you can go to the government and get your advisory opinion. The government publishes those advisory opinions. Those advisory opinions are very helpful in analyzing any particular situation you may have. So if you want to do something, you're not sure it's whether it's going to comply or not, you may look at these advisory opinions to give you some additional guidance. There were some fairly noteworthy advisory opinions that came out in 2023. So you might want to take a look at those. Don't forget about your state laws. In addition to those federal laws, your states probably have similar laws. Make sure that you're complying with those as well as the federal laws. Let's talk briefly about telehealth. Big news here is, as you know, I've seen numbers that telehealth expanded like 12,000% during the COVID-19. The government put in place a lot of flexibilities. A lot of states put in place flexibilities to allow telehealth, including allowing people to provide telehealth into the state, even though they weren't licensed. Bottom line here is most of those flexibilities have gone away. So you need to go back and look to the extent you're providing telehealth to make sure that you are complying with the law as they exist now, not law as it existed under the COVID-19 pandemic flexibilities. Among other things, you got to be aware of the payer reimbursement requirements. During the COVID-19, Medicare did expand payments for telehealth. A lot of those have been ratcheted back, not all of them. A lot of those will continue through 2024, and in some cases, particularly mental health, it may actually continue permanently. But just be aware that you check and make sure that your telehealth practices, your billing practices, are consistent with applicable law. Remember that when it comes to telehealth, you have to look at not only where you're located, but where the patient is located, because most states, all states, I think, state that you're deemed to provide that telehealth where the patient is located. So if you're providing care across state lines via telehealth, you got to look at that other states' laws when it comes to licensure, permissible telehealth methods, provider-patient relationship, scope of practice, informed consent, what do you need to do for remote prescribing, credentialing telehealth providers, corporate practice medicine, all of those things you need to make sure that you're complying with if you're going to cross state lines to provide telehealth. You need to be concerned about the federal laws too. The Ryan Haight Online Pharmacy Consumer Protection Act applies to prescribing, remote prescribing of controlled substances. It generally prohibits providers from prescribing controlled substances via the internet, which has been interpreted to include telehealth, most telehealth modalities, without having previously performed an in-person medical evaluation. There are certain exceptions that apply, and also during the COVID-19, DEA actually relaxed some of that to not require an in-person evaluation, but instead you could do an evaluation through telehealth and then do the remote prescribing. The DEA has, in February of this year, they have proposed rules that would modify those regulations for remote prescribing. Those haven't been finalized yet. In the meantime, however, the DEA has issued temporary rules that extend those COVID-19 flexibilities that allow you to provide that remote prescribing based on a telehealth visit rather than an in-person visit. They've extended that through December 31st of 2024. So if you are remote prescribing with controlled substances, you want to take a look at those requirements to make sure that you are complying with the requirements. The DEA is taking steps in order to expand telehealth, particularly in SUD situations. All right, let's talk briefly about artificial intelligence. It's all over the news, kind of the hot topic right now. And the law is struggling to catch up with AI. As commonly occurs when you have these technological advances, it takes a while for the law to catch up. Some of the common uses in healthcare are things like imaging, clinical decision support tools, research, virtual assistants, and others. The concerns with using AI in these situations is that the AI formulas, that it may result in unintentional bias against minorities or whatever. Also, the results are only as good as the information that you put in. So if it's garbage in, garbage out, you may get incorrect results. Part of that problem is it's kind of a black box. You don't know really what goes into the algorithm when you're doing the AI or using that AI. So how do you know what factors they're taking in? Do you know that those factors are relevant such that the results are reliable? Because of the concerns about AI, back last October, the Biden White House actually issued a blueprint for an AI Bill of Rights in which they called for responsible development of AI. As part of that Bill of Rights, some of the elements that you need to be concerned about, or that should be, AI developers should be concerned about, or legislators need to be concerned about, is ensuring that the AI provides for safe and effective systems, that it protects against algorithmic discrimination, that it protects data privacy, that it provides for notice and explanation if AI is going to be used, that they have to consider, the human toll on all of this. Is AI going to replace your entire workforce, and how's that going to work out? So I have to consider human alternatives, considerations, and fallbacks. It's kind of an aspirational type thing. In October of this year, we got a little bit more concrete. President Biden issued an executive order, a lengthy executive order addressing the use of artificial intelligence. It's a directive to a lot of government agencies in order to take steps to evaluate and put in place timelines for establishing rules and guidance for telehealth. When it comes to the healthcare issues, HHS was required within 90 days to establish essentially a task force, and that task force has 1 year to come up with a strategic plan and policies and potential regulations that affect the deployment of AI in the healthcare sector. So we'll need to watch for that. In the meantime, you need to be concerned about compliance concerns that arise regarding artificial intelligence. For example, the privacy of data input into the AI, that could violate HIPAA, 42 CFR Part 2, could be Section 5 of the FTCA, could violate state laws. So be concerned about the privacy issues if you're inputting or allowing a vendor to access your data, especially protected health information, because they may use your protected health information improperly and violate HIPAA in doing so. Got to be concerned about the unlicensed practice of medicine. If you're an AI developer or relying on AI to just make decisions, without having a licensed healthcare provider involved or making the ultimate decision-making authority. You still have to be licensed, in most cases, to provide healthcare, and simply relying on AI may constitute the unlicensed practice of medicine or similar statutes. Could also result in malpractice if the reliance on the AI is inconsistent with the applicable standard of care. And probably the standard of care is not advanced such that reliance on AI is consistent with the standard of care. So you need to double check and make sure what you're doing is appropriate under the applicable standard of care. Got to be concerned about billing. You may be relying on AI tools to bill, but you may not be getting the right results consistent with law. If you don't, it's not a defense that you just relied on AI. You're either compliant or not. And if you're not, you can't blame AI for it. You got to be concerned about anti-kickback issues, particularly if you're submitting false or improper claims. The government, interestingly enough, has also warned about situations where AI developers develop AI in a way that it comes out and steers patients to a particular provider in exchange for payments. In that situation, they've said, that may be a violation of the anti-kickback statute. Also got to be concerned about anti-discrimination laws. If the AI, the formulas that come out of that, the results of that basically result in prohibited discrimination against persons, whether it's disabilities, whether it's race, whatever it may be. In fact, I'll talk more about it later if I have time. HHS has proposed their new Section 1557 rules for discrimination. As part of those new rules, it specifically prohibits discrimination through the use of clinical algorithms in decision-making. So be aware of the discrimination effects. There could also be FDA implications because some AI tools may actually be regulated under the FDA. There are exceptions for a lot of software, but some of the software, some of the stuff that AI does may not fit within the exception. You also have to be worried about electronic health record certification. In April of this year, the ONC actually issued a proposed rule for certified health technologies to increase trust in predictive technologies, i.e., that it's new standards that should apply. Now, this is a proposed rule, but it would be applicable to AI that's developed in conjunction with EHR programs. You'll want to watch this because this is one of the first ones that's coming out, and it may serve as a basis for legislation in other contexts. NIST has actually published guidance for developers of AI as well as users of AI that talks about the risks and a framework for responsible development and implementation of AI. You may want to take a look at this if you are going to rely heavily on AI or developing your own AI. The AMA has published its own policy concerning the use of AI by physicians. The bottom line when it comes to AI, stay tuned as the law attempts to catch up with the federal laws. I think over the next couple of years, you're probably going to see a lot of legislation, a lot of regulation concerning AI as it tries to catch up, not only at the federal level, but the state level. There are actually some states that are beginning now to actually legislate on AI issues. So make sure that you watch out for that. In the meantime, however, beware of the risks under the current framework that we talked about earlier, as well as others that you might be able to identify. All right, the no surprise billing rules. Those are out there still, right? Those came out a couple of years ago. There's two parts of it. There's the part that applies to insured patients that limits the amount that an network can bill or get paid for services to a patient. There's a separate rule that applies to self-pay or uninsured patients. That's the one that requires you to provide a good faith estimate of your charges before you provide services to the patient. As originally structured, that rule not only applied to the main provider of services, but it also applied to those co-providers. So you are required as the main provider to reach out to these co-providers, labs or whatever, to get their good faith estimate. They have tabled those co-provider rules for the foreseeable future. Those are not enforceable now. That's good news. But you still have to comply with the good faith estimate rules. Going back to the insured patient situation, the out-of-network situation, a lot of developments over the past year dealing with the IDR process. Texas, which seems to lead the way in a lot of litigation against the government, attacked the IDR process, the Texas Medical Association. That's ongoing, but there is a series of decisions that came out of that undermine the government's interpretation and application of the IDR rules. As a result of that, the government has proposed new rules addressing the IDR process. Those have not been finalized. The government did, for a time, suspend that IDR process in response to the litigation while it tried to catch up and correct its situation. It has now resumed individual claims and is working on resuming the batch claims, at least last I heard. The government has issued FAQs addressing the no surprise rules in the IDR process. You can access those at that website. Actually, at this website, you can go there and it'll give you guidance concerning how you go through that IDR process over the last, given the changes over the last couple of months. If you want to know more about the kind of the history of that IDR process, what's going on, you can go to this website. The government gives you updates concerning the IDR process. The government has a website specifically designed for the no surprise billing rules. There's provisions that on the website that instruct or educate patients about it, but also provides resources for healthcare providers. All right, let's talk next about the hospital price transparency rules. This has been in place. It's the one that requires the hospital to publish a list of the hospital standard charges in formats that are required by the regulations. It's got to be posted through the hospital's website. I wanted to point out that you're supposed to update that at least annually. So if you haven't done it in the last year, it's time to do it again with the start of the new year. Might be a good time to check on that. A couple of years ago, or a year ago, the government actually increased the penalties against hospitals who are not complying with that. When you look at the history of the enforcement actions, it's really ticked up in the last few years. The government now is beginning to actively enforce that. There's 14 reported actions. The penalties range anywhere from about $57,000 to up to almost $1 million for violations of the rules. In most of these cases, if you look at them, it appears that CMS sent a warning letter first, and for whatever reason, the hospital just blew them off or didn't comply for some reason, or I guess. But the bottom line is, if you haven't been complying with that price transparency rule, the stakes are higher now, and you need to make sure that you're complying with it. For more information on the price transparency rule, you can go to this website, and it contains a whole wealth of information, technical and otherwise, concerning how you comply. All right, I wanted to mention the Telephone Consumer Protection Act. This is that statute that generally prohibits robocalling or using pre-recorded voicemail messages, those annoying ones you get usually at dinner time or other times of the day. This is the law that's supposed to prohibit that. There's different aspects of it. The one that most applies to you is the use of robocalling. You're using pre-recorded voice to deliver messages, except there are exceptions for emergencies, or there's actually an exception that applies to healthcare messages. I'm going to come back to that in just a minute. If you are using these pre-recorded voicemail messages or the automatic phone dialing systems or the robocalling, then, for things like bill paying or things like that, you need to be aware of compliance with the TCPA. If you fail to comply, you can get hit up with damages. And the problem with it is you have plaintiffs' lawyers who are out there and bringing class actions for violations of the Telephone Consumer Protection Act. So those penalties can really add up. Now, as I mentioned, there is an exception for healthcare messages in the guidance that the FTC issued. Those healthcare exceptions only apply to certain types of healthcare messages. It's not payments, calls about the bills, that type of stuff. It only applies to calls to describe a health-related product or service that you're providing, calls for treatment of the individual, relating to treatment of the individual, like appointment reminders, prescription refill reminders, etc., or calls for case manager to care coordination for the individual to direct or recommend treatment alternatives, therapies. So it has to be directly linked to the care of the person, not necessarily just business functions. Effective in July of this year, they placed additional limits. Even if you're allowed to make those calls, you've got to limit the number of calls to no more than 1 per day or 3 calls per week. The FCC has issued additional proposed rules that would beef up the TCPA, so make sure that you're monitoring that. For more information about how those rules apply, including in the healthcare sector, you can go to this resource there. All right, let's talk briefly about antitrust. What is antitrust? That does not mean you just don't trust somebody. This is those laws that prohibit unfair competition or agreements to restrain trade or monopolies or those types of things. If you engage in that misconduct, big penalties can rain down upon your head, including criminal fines, civil penalties, prison terms, and the like. Now, for the past years and years, we have been relying on guidance that the FTC and DOJ put out in 1996 that were essentially treated like safe harbors, that if you structured a network or some kind of agreement with who would otherwise be competitors, if you structured that arrangement to fit within these FTC guidelines, then you were probably safe in engaging in that conduct. But guess what? This year, the government threw those out. Those are no longer effective. So as a result, we are left scratching our heads about, okay, well, what does this mean? What does this mean when it comes to potential agreements with competitors or with others? If we want to enter into a network to do joint marketing, or we want to enter into a network or use some kind of joint negotiations with payers, what can we or can't we do? Haven't got a lot of guidance. We're going to have to watch out for this, but just be aware of those, that's a risk area now, and you may want to carefully consider and discuss with an antitrust lawyer what you can and cannot do, because what you did in the past may no longer work. Anti-discrimination rules. These were a hot topic under the Obama administration. The Trump administration seemed to kind of ignore them a little bit, kind of peeled them back. With the Biden administration, they are now coming back to the forefront. There are a number of different anti-discrimination laws, including the Civil Rights Act, the Americans with Disability Act, the Age Discrimination Act, the Rehab Act, and the Affordable Care Act, Section 1557, and of course, state discrimination laws. This past year, the government has issued new rules, new proposed rules to strengthen the Rehab Act, and also new rules concerning Section 1557. Actually, that came out in 2022. Section 1557 specifically applying to healthcare entities. Those rules have not been finalized. I would expect those out this year, so you'll have to watch for that. These are the rules, all of these rules potentially apply to discrimination situations involving persons with disabilities, persons with limited English proficiency, sex discrimination, physical access, websites, making sure your websites comply with ADA requirements and are accessible, service animals, including dogs and mini horses, things like that. But the ones that I see you guys dealing with the most are persons with disabilities and persons with limited English proficiency. The general rules for those with disabilities, if they show up to receive services, you've got to provide auxiliary aids to make sure that they have, that you provide a way for effective communication. Note that it includes persons with the patient, not just the patient themselves. So if the patient comes in with a mother who is deaf or blind, you've got to provide auxiliary aids for that person. You can't charge the patient for those costs. You can't rely on the person accompanying the patient to, interpret or to provide information. This is just a cost of doing business. You've got to provide those auxiliary aids for persons with disabilities. With limited English proficient patients, those who come in and don't speak English, then you generally have to provide meaningful access. That's generally interpreted or means that you provide an interpreter and translate key documents. Again, includes the person with the patient as well as the patient themselves. You can't charge the patient for your costs in doing that. You may not require the patient to bring their own interpreter. You may not rely on a person accompanying the patient to provide that. You can't refuse to see the patient because of that. Those are just the rules that apply in those situations. You can look at some of the recent enforcement actions. The government, again, has kind of stepped up enforcement of this. The good news is in most of these cases, the government just comes in and gets some kind of agreement with you that you'll engage in policy and training. But at least in one case in March, they actually imposed a $7,500 fine on an OBGYN who refused the patient's request for a sign language interpreter and instead canceled her as a patient. That is not permissible. HHS has taken different actions. They've issued some proposed rules concerning how to, or not proposed rules, but at least some guidance, a report concerning how to increase language access for those with limited English proficiencies, including talking about internet access, telephone access, access to programs and activities. These do not necessarily apply to you directly yet. We don't have it in the proposed rule, but it may be coming down the pipe. You may want to take a look at that. The Department of Justice has proposed rules for accessibility for web and mobile app services. That may be coming down the pipe also. For disability resources, you can go to this website, and They've got sample policies charts, things like that to help you in your compliance with the disability issues. Reproductive rights in the wake of Dobbs. There's the anti-abortion statutes that have been passing or been implemented in many states. The Biden administration has been taking steps to try to curb or at least minimize the effect of that to the extent that they can, including the DOJ asserting claims that EMTALA trumps abortions to the extent EMTALA applies in hospitals. They've taken steps, the administration has taken steps to make sure that birth control is available, and has argued that federal law that allows for the mailing of that it trumps contrary state laws and the like. The government actually has a website that talks about reproductive rights and what at least the government's perception of those rights are. The government has been involved in litigation over a lot of that, particularly with the availability of mifepristone for chemical abortions. It's kind of gone up and down the courts. Right now, last I heard, it's pending at the Supreme Court to determine whether or not the government can still, DOJ takes the position that the government, under the federal law, that still can be provided even in states where their abortions are prohibited, that it may be able to be provided through mail. But we will have to see whether those laws actually survive. All right. That is a very quick summary of kind of the things that have been going on in compliance over the past year, kind of what I think you need to be focusing on for the next year. If you need additional resources, you can go to our website. We've got a lot of webinars we've got that are recorded and available for free. We've got a lot of publications. If you're not on our mailing list and you would like to be, just make sure you send me an email. We'll make sure you get added to our mailing list of client alerts and free webinars and the like. Otherwise, that is it. Thanks for your patience. I hope you all have great holidays. If you have any questions, you can submit those using the chat feature, or you can shoot me an email and I will try to respond to those offline. And there you go. Thanks very much for participating today.